The trial is in the matter of case number CFI 030/2022 before Justice Sir Jeremy Cooke. The claimant is represented by Norton Rose Filbert, Middle East LLP, and the lead counsel is Mr. Tom Montague Smith, KC. The defendants are not present. Thank you very much.
Just two things, Mr. Montague Smith, before you begin. The first is that my internet service provider tells me that at some point between 9 o'clock and 1 o'clock this morning, we will lose connectivity for 10 minutes while they do something. So if I suddenly disappear, I'm afraid that's what it will be. And I shall simply rejoin as soon as I can.
Very good.
When they say 10 minutes, of course, you never know, but on the whole, they're quite good. So I hope that's
very good.
The second is equally a technical issue. Over the weekend, the DIFC case management system was closed. So the end result is that whilst I've read your skeleton, and I have, of course, familiarity with this from the past, including reading many of the documents, some of the documents to which you've referred I had not seen because I was unable to access the case management bundle on Saturday. So whereas you might have thought it would follow a reasonably quick course, it may be slightly longer because I may need you to take me to some of the key documents that you otherwise probably would have expected me to have read.
No, that's absolutely fine. Thank you very much for that indication, my lord. So with your permission, you know already the defendants have indicated they're not going to participate. We've seen an email this morning from the second defendant solicitors saying they're no longer instructed. We don't think there has been an application to come off the record, and certainly we've seen no notice of change. But the upshot is that neither of the defendants have filed any witness evidence for the purpose of the trial. Neither of the defendants have complied with your lordship's orders for disclosure or document production. The first defendant has, however, indicated that we think he wants to continue to appeal against your lordship's money judgment against him. That was the immediate judgment. Quite how he can do that without appearing at trial, we're not sure, but there we are. It indicates the rather artificial nature of the exercise from their perspective. The excuse given, and it becomes relevant later on, is firstly in relation to the first defendant, he does not wish to submit to the jurisdiction. Having filed a defence, we think that's really the thinnest of veneers. The second defendant says she's run out of money and also may or may not have been undergoing some surgery. But we have no evidence as to any of that. Those are just the assertions that are made as to their reasons for not being here. My lord, I've already mentioned you've given a judgment for the money. What is left is the claim for the declaration. And so what we seek is a declaration that Mr. Maness is the beneficial owner of Five Dining Corporation and has been the beneficial owner since its incorporation on the 10th of October 2019.
Yes. Now, I'm just curious about the appeals position.
Yes.
That'll be a matter for the Court of Appeal to sort out, I guess, but is there a technical difficulty about them pursuing the appeal? I mean, I rather think the registry may want some directions about what to do about it.
Well, my lord, you may not recall this, but there was a question about whether in part the appeal was too late.
Yes,
and the way Mr. Taylor put it,
referred the whole matter of permission and extension to the Court of Appeal.
And that has been taking its course. And Mr. Taylor made some submissions. The Court of Appeal said he needed to make an application. He made some more submissions. We don't think he's made an application. If it comes to it, we will deal with it. But it's all in the hands of the Court of Appeal. And they are aware that there is that issue as to timing.
Yes. And is that in the hands of a particular member of the Court of Appeal or what?
That I do not know. That I do not know. I've seen a direction from the registry passing on the direction from the Court of Appeal to the effect that if they want to seek additional time, they need to make an application. I think the way that Mr. Taylor was presenting it was that your lordship had referred it to the Court of Appeal, and therefore there was an ongoing application which could sort of be passed across. But the Court of Appeal have said, no, you need to make an actual freestanding application. And so that is where that has got to at this stage.
Well, my recollection is I don't think it ever actually made a formal application to the first instance court, Eddie, for an extension.
Not on paper. I think what he is saying is that he made an oral application to you.
Yes.
And you said no. But there we are. So that will take its course. He by the way, just so you're fully apprised of it, he has also said that he wants permission and an extension of time, but then he wants a stay of the appeal.
Pending what?
To see pending this trial and possibly the receivership. So it's very, very unclear what is going on exactly. Our view is the whole thing's pretty abusive, and we'll deal with it with the Court of Appeal on that basis. But there doesn't. It's very unclear whether there is a concerted and resolved decision that has been taken actually to contest your lordship's order. And you've seen the grounds. You may or may not have turned your mind to them, but it's very unclear what the grounds actually are. There's a lot of reference to constitutionality and Union Supreme Court, but not a lot of clarity about what the complaint really is. So there it is. Now you'll recall, my lord, that in December in the receivership application, the defendants ultimately conceded that as at that date, and therefore going on from there, Mr. Manus was the beneficial owner of Five Dining. And you'll recall that was because they said that was the result of a transaction, or there was a transaction which took place between them in November. Or we don't know quite when it was, but they reported it to us in November in their evidence. They've never given us a date. And that was what they called a sale of the shares.
Well, an agreement for a sale.
An agreement for the sale of the shares, correct. And you'll recall our position at the receivership was if there really was an agreement for the sale, the effect of that would be the beneficial ownership passed. But our case is that he has always been the beneficial owner, and that matters, we say, for really three primary reasons today. And so I'm going to start, if I may, at the end and explain to you why we are still seeking a declaration. And then I was going to, our evidence in relation to the underlying facts is primarily given by Mr. Stottard, the solicitor acting for the defendant, for the claimant. And so while his evidence is pretty formal, I was going to then ask him to be sworn in and just give that evidence on oath, on affirmation. And then I was going to take you through the various factors which I say can lead you to the conclusion that Mr. Manus always was the beneficial owner. But anticipating that the sort of discussion we had last time, what's the point of doing this now that they concede the position? Now I just wanted to make three short points on that. The first is the most obvious one, but perhaps the least significance in a sense, is the question of the price that was said to have been agreed. So Miss Ziller asserts that she is owed a debt by Mr. Manus. He says he intends to pay that from the proceeds sale of the restaurant or its business. And we say, well, if Mr. Manus always owned the shares beneficially, then that proposed sale can't produce a proper price, and it will clear things up if the receiver is aware that there are no competing claims when it comes to distribution of the assets. Otherwise, we may end up having this fight later in any event. I accept it.
That's unlikely, isn't it? Because the sale is not going to produce enough to satisfy the judgment. So unless he's made bankrupt in the DIFC, the receiver will simply pay the money to the judgment debtor. She won't have a claim on the fund as such, will she?
Well, no, that's correct. She doesn't have a proprietary claim, but then neither do we. And then the receiver will be in a position of saying, well, I've got competing creditors here. And he's already doing that. So he, at the moment, if he produced a report where he said the trade creditors of Five Dining are these, and they will need to be satisfied. So, I mean, it's probably pragmatic, but if she was to bring a small claim, as she has intimated she might, sorry, she hasn't intimated that she might, but she suggested that this claim should end up in small claims. I apologise, but if she was to bring a small claim, she might compete with us for that sum, and then the receiver would be in a position. But it is a small sum, and we obviously wouldn't have spent all the money that we spent on this claim simply for that purpose. But we are here now, and there we are. The second point is that there are very similar proceedings in Belgium about another company. That's the MA Development, and that's the one that owns the Paris restaurant. It used to be a French company, and it was re-domiciled to Belgium during the course of the English proceedings. And what happened in that case is that the shares in the company that owned the restaurant were transferred to Miss Ziller. They were then transferred back again to Mr. Mannis, and then they went back again to Miss Ziller, which is where they are now. So we're having a fight in Belgium about who the true owner of those shares are. And Miss Ziller now claims that when the shares went back from her to Mr. Mannis, that, she says, was done without her knowledge. And she says that that was a donation or a gift to her to recognise her contribution to the original investment in that restaurant. So although the specifics of the allegations are slightly different, it's a very similar situation to the one that we faced in Dubai. And so we consider that a clear finding in this court that Mr. Mannis and Ms. Ziller have taken steps to, in effect, pretend that Ms. Ziller owns the DIFC restaurant, we consider that will help us to demonstrate on a similar fact basis the same thing is happening in Belgium. Except we probably, we wouldn't have launched the claim purely for that reason. But we are here now, and having got 3/4 of the way through the proceedings, the question is the additional benefit worth the candle being the additional costs? But the final point is this, that the conclusion that Mr. Mannis beneficially owns the shares on our case falls out from the facts, but on the defendant's case, it's dependent on the agreement that they say they reached. And so, and we know that they have, on their case, varied that agreement once in order to obtain a tactical advantage. Your lordship may recall that what they did was they reduced the price from $250,000 to about to 500,000 dirham, and that was in an attempt, we say, to have the claim reallocated to the small claims division. But the upshot of that is that if there's an ongoing debate about whether the beneficial ownership is created by the original situation or by this agreement, then that debate could have relevance if they decide to do something about what they say is their agreement. So if they did something to make that agreement ineffective, to cancel it, to send the shares back or whatever, then on their case, that may mean that Ms. Ziller and the children retain an interest in the shares if they were say, all right, fine, we're just cancelling that agreement. Now they're not entitled to deal with those shares, but it could certainly complicate things if they act in breach of your lordship's order and say, well, actually, we've thought about it and we don't want to have that agreement at all. So those really are the three reasons why we say there is some utility in the declaration that we seek. We want finality in relation to this issue in the DIFC. There is the issue of the price, and then there is this similar fact-finding point. And the test is whether or not there's a real and present dispute which is going to affect the parties. That's the Unite the Union case, and we say that there is. Now you might say, well, this is all a bit disproportionate just for those aims. However, if proportionality is the issue, the point at this stage is that the defendants are not attending today. We were always going to have some arguments about costs of these proceedings, and then your lordship would have had to apply your mind to the merits of the issues. And so the marginal cost, we say, of doing this exercise over and above doing that is negligible. So if your lordship asked the question, which is sort of memorably put in one of the authorities, will you be shouting in an empty room if you were to make this declaration? You say that clearly there's some value in the declaration we seek. So that's all I was going to say on the question of declarations. Try to explain what we're doing here with you today. And as I say, I started at the end really. So unless your lordship wants me to give any kind of broader overview of the actual claim, what I propose to do is just come on to get Mr. Stottard's evidence out of the way, and then come on and make the submissions that I was going to make. What I'd
really like you to take me to on the documents are what the defendants have said at various times. So I would like to see the defences.
Yes.
And I'm conscious that there are a lot of witness statements and affidavits from them, most of which don't touch on this issue at all. But I actually would like to have my attention drawn to the specific paragraphs in the various witness statements or affidavits that say anything that touches on the central points at issue.
Yes. And I will do that. And what you will see is that the number of those incidences is very small compared to the amount of evidence that has been provided. They have kept their powder very dry, almost all the way through these proceedings. But I will show you what they say in their defences and what they say in their affidavits. Just as by way of just a preface, though, when we get to it, what you're looking for, the points we make are these. Firstly, on the facts, I say, I'll show you the defence, but I say that the defence concedes a great deal, and the effect of it is that it ultimately places the burden of proof onto the defendants, which we say they haven't met.
When you say the defendants, do you mean both defences?
Well, the first defendant's defence, and when one couples that with the affidavit of Miss Ziller, Miss Ziller's defence is very thin. She effectively doesn't admit anything. Both defences are pretty thin, but at least the first defendant gives a positive case. But Miss Ziller does also advance a positive case about how this all came about in her affidavit, and I'll show you that. But the point there is that that there were a series of transfers of these shares. They start with Mr. Manus, they go to the company Five Aces, and then they go to Miss Ziller and the children. And Mr. Manus accepts that the transfer from him to Five Aces was only a transfer of title. It didn't carry beneficial interest. And so, having conceded that, the question comes down to who had the beneficial interest before that transfer took place. That's the sort of central starting point of my first point. And then the second point is I identify a number of factors which we say your lordship can rely on to be confident that Mr. Manus was always the beneficial owner. Inevitably, that is a bit of a shopping list because we are obviously piecing this together a little bit. But I will try to show you the most significant material in relation to that.
I have one question of fact which arises essentially out of the chronology, which is in fact the actual date when Mr. Manus ceased to be a director of Five Dining, because I think it's referred to in two places as on different dates, the 24th of August 2020, the date of the first transfer, and also the 21st of January 2022.
Yes, I apologise for that. I think the first is an error, but I will double check that.
Right, thank you.
I'm fairly sure that it was January 2022 that is the correct date.
Well, in your skeleton, that's what you say. But,
yes.
Say the chronology says something different, and I couldn't access the original documents to check. There was one other point that arose in relation to chronology. Oh yes, there are two entries for Five Aces transferring its shareholding to the second defendant and her children, both the 17th of January 2021 and 2022. But it is in fact 2022, isn't it?
It is, yes. Yeah, and apologies, I should have picked that up.
All right. So Mr. Stothard first is the plan, is it?
That's correct, yes, and that's so. What I'm going to, I'm not going to take him to every witness statement he's filed in these proceedings, but I was going to take him to his affidavit, his first one, because that sets the scene for the scale for the freezing order. Then to his first witness statement, and then to his 9th witness statement, which is the latest one prepared for trial, and that is it. So if we could have Mr. Stothard on the camera, please. And I believe he wishes to affirm.
Mr.
Could someone administer the affirmation, please?
Yes, Sir Jeremy. Mr. Paul, can you please confirm your name and occupation for the record?
Yes, my name is Paul Michael Stothard, and I'm a solicitor.
Thank you. Please repeat after me. One second. Sorry. I solemnly declare and affirm
I solemnly declare and affirm
that the evidence I shall give
that the evidence I shall give
will be the truth, the whole truth, and nothing but the truth.
will be the truth, the whole truth, and nothing but the truth.
Thank you. Mr. Stothard, I'm going to show you 3 statements and your signatures in relation to that. And then I'm going to ask you to confirm, firstly, that they're yours. And at the end, I'm going to ask you to confirm that the contents of them all are true to the best of your knowledge and belief. So I'm just going to take you through the statements first and then get you to make that confirmation in relation to all of them. So as we go, please do say if there are any corrections to be made. Could you turn, please, to bundle D, if you have it, in tab 25?
Yep.
And on page 172, do you see there your first affidavit?
I do.
And if you go down, please, to page 200.
I've got it. Yep.
Your computer's faster than mine. Do you see there your signature?
I do. Yes, that's my signature.
Thank you. And then if we go forward, please, to tab 28.
Yes.
And that is, do you see there your amended version of your first witness statement?
Yep.
And then page 231.
Yep.
Do you see there your signature?
Yes.
And then if we need to go next to bundle K, in tab 146. It's page 2742.
Okay.
Do you see there your 9th witness statement?
Yes.
And page 2757.
Yep.
And is that your signature?
Yes, it is.
And can you confirm that you believe that the facts stated in the affidavit and the 2 witness statements are true?
I can confirm that. Yes.
Thank you. My lord, I don't know if you have any questions for Mr. Stothard. His evidence is in the main producing documents and explaining things that have happened in the proceedings.
Yes, could you get him to confirm the schedule of costs?
Yes, certainly. So, Mr. Stothard, if you go to bundle K, and it should be towards the end, there are a number of different schedules of costs. And you should, if you turn to page 3590, you'll see the schedule to the costs orders. That's where it all starts.
Okay. 1 second. Yep, I got it.
And if you then turn over to page 3592, do you see there a summary of all the costs incurred by the claimant?
Mm.
And is that your signature at the bottom left of that?
Yes.
And can you confirm that the costs stated in that schedule do not exceed the costs which the claimant is liable to pay in respect of the work that the statement covers?
I can confirm that. Obviously, I would just clarify. I have received information from London solicitors Mishcon de Rea that they equally have applied the same test, as it were, to their costs, which are listed in this schedule. So they have confirmed to me that they are also not claiming more than they will be charging.
Thank you. And if you go over the page,
Just remind me, Mr. Stothard, the Mishcon de Rea costs are costs incurred in these proceedings and not in English proceedings.
That's correct. We've excluded not only the English proceedings, but the JJC and the onshore proceedings as well from all of these costs.
Thank you.
and my lord, we do have Mr. Style, Mr. Simon Style on the call. If you want him to confirm the same, he is the individual from Mishcon de Rea who's provided his signature at the bottom right-hand corner of this page, which
Yes,
confirms
well,
that.
if he's on the call, he can justify his presence by confirming that in evidence. Then,
Very good.
if he doesn't mind.
I'm sure he won't mind, and I'll ask him to do that in just a second.
Yes, well, let's finish with Mr. Stothard first.
Thank you. And then, Mr. Stothard, if you go forward a page, as I understand it, that the following page is then simply a summary of all of the different cost schedules which follow. And then starting at 3594, you see another series of cost schedules. And for your purposes, they run to, excuse me, they run, I think, to page 3609.
I think so. Yeah.
And can you confirm that those are the costs that you have condensed into the table which we referred to in the first instance?
That's correct. Yes.
Thank you very much. My lord, I don't have any other questions for Mr. Stothard. Do you have anything else that you would like him to deal with at this stage?
No, I don't think so, because it's essentially the documents I'm going to be looking at. So thank you very much, Mr. Stothard.
Thank you. Thank you, Your Honour.
I apologise, Mr. Style, who may or may not have a suit on, but I will ask him to turn his his camera on. He won't thank me for this, I suspect. I think he's trying to speak.
He's on mute at present.
I don't have him on mute.
Well, down the bottom left, I've got a thing saying, I haven't got a picture of him. Oh, no, hold on. That's, yeah, no, sorry, that's Mr. Stothard. No, I don't know what's happening to Mr. Style. Are you there, Mr. Style?
Well, perhaps as it relates to costs, we can allow Mr. Style.
We can come back.
We
can come back to it, and if he wants to put a tie on in the meantime.
Hello, can you hear me?
We can hear you. Thank you. I'm sorry about this.
Are you visible, Mr. Style?
Hello, can you hear me?
We can hear you, but we can't see you. Don't think he's hearing us.
No. All right. Well, I might just ask
tell you what,
team...
Mr. Montague Smith, why doesn't someone send him an email? Yes. And we'll success.
That might explain things. Why don't we ask Mr. Style to find a quiet space, and then we'll come back to him. We'll come back to him in an hour or so.
Yeah, we'll come back to you, Mr. Style. If you can hear us, we'll come back to you at some more convenient moment.
Hello.
Yeah. Could someone send him an email, please? I think we've set a hair running here.
Yeah. Send him an email and say if he can get in touch later, and not to keep saying hello to us now, and to turn his microphone off.
Very good. All right.
Hello.
Paul, could you get someone to give him a call?
Yes, I'll do that now.
Thank you
very much. It wasn't such a good idea, Mr. Montague Smith. There we are.
Well, I'll fall on my sword for that one. All right then.
Well, it was my suggestion, I'm afraid.
Well, I know, but I took it up quite
Hello,
quickly.
can you hear me?
There we go. All right, my lord. I've got in mind that you'd like to see what the defendants say about all of this. As I said, my submissions will be in two parts, or rather three parts. The first is my position that the logical consequence of the defence is that all other things being equal, Mr. Manus would have been the beneficial owner at the start. Sorry about the camera.
That's all right.
Just going to pin it because it's distracting. There we go. It would place the burden on the defendants to allege and prove some other arrangement back before the transfer in August 2020 to 5 Aces, and they haven't done that. The second point is then some facts on the basis of which you can conclude that he was a beneficial owner anyway. And the third, I deal with the pleaded case that the Dubai divorce has some precluded effect. That's still pleaded. You've decided it, but so I won't deal with it very extensively. But that is the other part of the defence. So starting then with the position in October 2019. That's on the 10th of October 2019, 5 Dining is incorporated. There's no dispute that Mr. Manus was the registered shareholder at that time. And then on the 24th of August 2020, so just under a year later, the shares are transferred to 5 Aces Limited. And we know that 5 Aces is a JAFSA free zone company. And then from there, they go to Miss Zilla and the children, on, as you've already recorded, the 17th of January 2022. And then, of course, after that, your lordship's ordered that they be transferred to the receiver, which is what's happened in January. Now,
and who is the owner of JAFSA, the JAFSA company?
Well, we've not seen any of the corporate documents in relation to that, but the defendants say that Ms. Zilla was. They say that is why, and I'll show you this in a moment. Well, let me take you straight to the defence. In fact, to the first defendant. If we go to Bundle A, tab page 10. Page 9, sorry. And it's paragraph 5, where this is the first defendant's defence. He admits various paragraphs of the particulars of claim and avers as follows. With respect to paragraph 14, 5 Dining's tenure of the restaurant is by lease.
Sorry, bear with me.
Yeah, no problem.
Why isn't my fine page working? Never mind.
We're on page 9.
Yeah.
And it's paragraph 5B. And the positive case is set out with respect to 17. 17 be the allegation of the transfer.
Yeah.
The first defendant's transfer of the shares to 5 Aces on the 24th of August 2020 was of the legal title in circumstances where the second defendant was already the ultimate beneficial of the owner of the shares and owner of 5 Aces. And then you get paragraph 7.
Yeah.
The claimant's right to the declarations claimed are denied, save that it is averred that prior to the order of the family court transferring the ownership of the shares and an execution by the DIFC court and the registration of the transfer pursuant thereto as pleaded in 6, the second defendant was the sole beneficial owner of 5 Aces, which had title to the shares prior to their transfer, as ordered by the family court. And then he denies the ownership. So the position of the second defendant is not really made clear. Paragraph, page 12. Paragraph 5. Claimant's allegations against the second defendant set out in paragraphs 22 to 23. Paragraph 6, in summary, the claimant alleges that the shares and all 5 aces are ultimately owned by the first defendant, and that therefore by implication the second defendant is not the legal and or beneficial owner of the shares and 5 aces, and then sets out passages from particulars of claim. And then paragraph 8, paragraphs 22 and 23 of the particulars of claim are wholly unparticularized but denied notwithstanding. And then the second defendant is the legal and beneficial owner of 33% and 5 dining and the 100% owner of 5 aces, and then complains about lack of evidence. But the upshot of this and I'll show you what Miss Zilla says in her evidence in a moment.
Silly question, probably, Mr. Montague Smith, but do I take it there is no register that one can check the shareholdings in 5 aces?
Yes, so it's not publicly available information. We've asked them to provide the corporate documentation.
Yes.
It's one of the requests we made, and it's not been provided.
I made an order for it.
You made an order for it, yes. I'll show you the orders in a moment. It's one of the points I make in relation to adverse inferences. But just starting logically from what the case is, as far as we know it, and although the second defendant hasn't really made clear what her defense is, the first defendant's case is very clear. He says he accepts that the transfer to 5 aces was only a transfer of legal title. So he accepts that beneficial and legal title split at some point.
Yeah.
And they were split with 5 aces, because on his case, 5 aces was holding the shares for Miss Zilla. She was the beneficial owner. So the question becomes, who was the beneficial owner before the transfer took place? Because if only title transferred, then if Mr. Manus was the beneficial owner, then beneficial ownership remains with him, because the transfer was never intended to affect a transfer of beneficial ownership. There is no case that at some stage Mr. Manus made a declaration of trust, for example, in favour of anyone else. There is no case that he disposed of his beneficial interest after that date. Or once title went to 5 aces. So if only legal title went to 5 aces in that transfer, then unless beneficial ownership already sat with Miss Zilla, there was nothing but legal title to be transferred from 5 aces to Miss Zilla and the children subsequently. Yeah. So that's why, yes.
Just in passing, paragraph 9 of second defendant's defence, 33%, not 34%?
Yes, so you're right. It should be 34%. I think that's probably a slip on the basis that the children have 33% each and she has 34%.
Yeah. Well, there we are.
There we are. So this, when we're looking at the question who had the beneficial ownership prior to the 5 aces transfer, prior to the 24th of August 2020, the starting point, as we all know, is that equity follows the law. And if you need authority for that, we've got Stack and Dowden. In other words, all things being equal, if you're the legal owner of something, you will also be the beneficial owner of that thing. And then if somebody wants to say that some other arrangement existed, then it's for them to, the burden is on them to explain it and to prove it. So that's the starting point, and that is fundamentally, in a way, why the way in which the defence is put rather simplifies things to some extent in these proceedings. Let me show you, if I may, what Miss Zilla's explanation is for this. It's in bundle K. It's tab 139.
Yeah.
and it's page 2545, which is paragraph 12.
Yeah.
And paragraph 12 is the closest we get to a full case from Miss Ziller about how this all came about. So on the 17th of August 2020, we thought that was the 24th of August, but there you are. Mr. Axel Manners transferred all of the shares in the DIFC restaurant to 5 Aces Limited, an offshore company registered in the Jebel Ali Free Zone, Dubai, which was fully owned and controlled by me. And this is why. In 2019, I began planning to move to Dubai and requested Mr. Axel Manners, who was in Dubai at that time, to establish the DIFC restaurant for me. The initial registration of the DIFC restaurant and the signing of the DIFC lease was done in the name of Mr. Axel Manners. However, the agreement was that I would be the owner and will manage the DIFC restaurant when I relocate to Dubai. I provided the initial investment funding to Mr. Axel Manners from my personal funds. Due to COVID-19 related circumstances, Mr. Axel Manners transferred all of the shares held in the DIFC restaurant to 5 Aces Limited only on 17th August 2020. So the evidence is that she had provided the initial investment money. The agreement was that she would be the owner somehow, but that was delayed by COVID-19, that she was the owner of 5 Aces, and therefore, in effect, the transfer to 5 Aces was the transfer to her. So that's really the shape of what she says about all of this. Now, I make in my skeleton argument 5 fairly short points about this, and what I was going to do is just take you through them very quickly, pausing whenever you'd like me to. I think that the first point that we would make is that the underlying allegation, putting aside the agreement, the underlying allegation of advancement of money, absent more, would not explain the creation of a beneficial interest in the company. And this is really for 2 reasons. Firstly, that there is a presumption that when a person advances money to their spouse, they do so, it's an advancement. It's not a loan. It doesn't create any kind of legal obligation associated with it. And it's a very weak presumption, but it requires some sort of evidential response, some sort of evidence to displace it. So
I'm very out of date on this, Mr. Montague Smith. I have a dim and distant recollection: presumption of advancement, husband to wife; presumption of resulting trust, wife to husband. Has that all changed with modern thinking about husbands and wives? Am I wrong about that?
I didn't think that was the position. I can show you where. I can show you where.
Does Stack and Dowden say that specifically?
Stack and Dowden.
My recollection may be wrong. It's such a long time since I looked at it. I may be wrong about that.
You might be. I'm sorry, I don't have the chapter and verse on it, I'm afraid. I'd understood it to be a presumption of advancement as between in both directions, but perhaps I'm wrong. I mean, I don't put too much weight on this, and I won't press it, but that was my understanding of the position. The only reason I refer you to Stack and Dowden is just to show you that even though it is, quotes, much weakened, it still exists. So there we are.
I'm not likely to put any weight on it in any event. You know,
very good.
But in reality, one's going to look at all the surrounding circumstances.
Yeah, I understand. I mean, that is true. Save if the point is, well, my wife paid for this and therefore it's hers.
Yes.
Then there's obviously evidential questions as to whether she did pay for it. We'll come on to that. Yeah. But even if she did, it's not going to create a a beneficial interest in the property that was then purchased. At most, it would lead to some sort of loan, and that's where the presumption of advancement arises. Usually, the question is after the event, and often in the case of looking for the husband's assets, what was that money a loan, or was it actually is it due back, or was it genuinely a gift to the wife? But even if there isn't a presumption of advancement, it doesn't create some sort of beneficial interest by itself. You need some sort of documented some sort of arrangement at least. The other point we make in relation to this is that their own position is that where the parallel situation arose in Belgium, it didn't result in a beneficial interest in her favour, because in Belgium the allegation is that she also provided that investment. And if you're still in bundle K and you go back up to paragraph 9, you'll see what she says about Belgium.
Do they have a law of trusts in Belgium?
Probably not.
Yeah, quite.
But I think her position is that it didn't create any kind of legal relationship at all. It was just that it created some sort of moral obligation on him, which he recognised by, quotes, donation.
Yeah.
But all of this is happening at broadly the same time, and the question is whether or not there's some implicit understanding that whenever she invests in a company, assuming that she did, or she helps him with the initial investment, she gets the company in exchange.
Yeah.
But that rather assumes that the solution to the second point, which is that there's nothing whatsoever to substantiate any of this. So there are no particulars, there's no independent evidence, and the most we have is this single line in a witness statement in an affidavit where Ms. Ziller asserts that there was, quotes, an agreement that she would be the owner. Now, she has chosen not to attend to answer questions on this evidence, and her assertions as to this should carry, we say, no weight whatsoever. But more to the point, if it was true, there would be abundant independent evidence to support it, which she hasn't produced. And in my skeleton at paragraph 37, we identified specifically in relation to this aspect some things that she has been ordered and the defendants have been ordered to produce, which she hasn't produced.
What about the nature of the agreement that she alleges? I mean, the agreement was that I would be the owner and will manage the DIFC restaurant when I locate to Dubai.
Yes, I mean, it could be an agreement to transfer shares in the future.
Yeah.
It could be. It's difficult to know. I'd read when I relocate to Dubai meant that she would manage the DIFC restaurant when she relocated to Dubai, because she goes on to say that the transfer of the shares was delayed by COVID-19. But it's unclear whether she's saying her arrival in Dubai was delayed by COVID-19, and that meant that the transfer was still only intended to take effect when she arrived. I agree, it's ambiguous.
Well, I read it as meaning the transfer of the shares, i.e. I would be the owner, was a future event, which has been delayed by, quote, COVID.
I see.
So I read both owner and manager. And is there any evidence of any expertise on her part in managing restaurants?
No. And when we come to it, we'll come on to it and look at the evidence of who was controlling the bank accounts, and things like that. It's very clear that it was Mr. Manus.
Yeah.
So there's no evidence, there's no direct evidence that she has ever done anything in relation to this restaurant, or that she would be placed to do so. And I think some of the points that we make, skeleton about documents missing support all of that, and the sorts of documents that would exist are, firstly, if this agreement existed, there would be some communications, even if it was an oral agreement, which evidenced the existence of that agreement, at least. If it was intended to be legally binding, as between husband and wife, they would have written it down somewhere. But even if it was wholly casual, it would appear in an email somewhere, wouldn't it? That there would be payments which would appear on bank statements for the money that was advanced, or said to have been advanced for the loans.
Yeah.
And there would also be, and I appreciate in a way this is a lawyer's point, but there should be an ultimate beneficial owners register. So in the DIFC, there is a legal requirement on the company to keep a register of its, quotes, ultimate beneficial owners. Those are the individuals who have direct or indirect control of the company, more than 51%, more than 50%. And that's set out in the ultimate beneficial ownership regulations. They've been ordered to produce that, but they haven't. And there's no good excuse. It's not said that doesn't exist. The other aspect is, as I've said, that some of this, perhaps the transfer was delayed, perhaps the move was delayed by COVID-19. And I suppose your lordship's interpretation might explain that. If the allegation is that the agreement was that there would be transfer once she moved, one could see that the move could be delayed. But I'd read it as saying the transfer itself was delayed. We saw no way that could work, and at least there would be documents evidencing attempts to effect that transfer, or at least some sort of discussion of that. And the other aspect, of course, is that when she did move to Dubai, there would be some correspondence about that and about how she would then integrate with the restaurant. There would be some emails showing her managing the restaurant, or manages in part by communication online. There would be all of this evidence, all of this documentation showing, explaining her story. And if it really was her restaurant, she would be interested in presenting us with all of that and saying, look, here it all is in black and white. And yes, this bit isn't written down because there was an oral agreement about it, but here is all the rest of it. All of that's been ordered, none of it's been produced. And so the result of that is that the court can draw adverse inferences under the rule in 2661 of the RDC. And so that's my second point is there's no positive evidence to support the positive case they're required to make. And my third point is, because they've been ordered to produce it, you can draw adverse inferences that all of those documents which must exist, either, or if her case is correct, either they don't exist, indicating that the case is not correct, or such of those documents, like bank statements, as must exist, would show something which undermined the case.
Were they in Paris before? That's where they were living?
I think that is right.
Well, there's a flat in Paris, isn't there?
There is a flat in Paris. That's Mr. Manor says that's his as well.
Yeah.
I believe that is right. I believe that they were moving from Paris. There's two more points just at this stage. The first is the general probabilities of the story that we've been told, and the next one, in fact, there's three more points. That there are two short points on the documents that we have actually seen, which I think will assist. Just dealing first with the logic of the arrangements. So the justification for all of this is that Miss Zilla paid for the startup. But the economics of this deal don't make any sense for Mr. Manus. So firstly, we don't know, because she hasn't told us, how much she is said to have spent on the investment. But Mr. Manus, we do know, was not receiving anything like the value that he would have brought to this enterprise. His evidence is that the only thing he received was a salary, and that salary was 144,000 dirhams a year. It's about $39,000. And you can see that it's on page in K, that's 2846, paragraph 20. So this is Mr. Manis's 6th witness statement in the English proceedings. And at page 2846, paragraph 20, he gives his evidence about the Dubai restaurant. And he says, I'm a director at FDC, that's Five Dining. This is the 3rd line, and work at the Dubai restaurant. However, I do not ultimately control or run the Dubai restaurant. Although it is a project I am, of course, involved in, I was not able to source finance which would have allowed me to invest in it as I had originally hoped to. Nevertheless, I know the claimant disagrees with this. And then he goes on at 21. He talks about the rent, because at this stage there was an argument about what his assets were and the freezing order. And he says, I'm currently, do you see at the end of paragraph 21, I'm currently arranging with FDC for an advance on my 144,000 dirhams salary of 75,000 dirhams. Now, our evidence, our information is that head chefs in the DIFC would normally get 3 or 4 times that sort of income. Yes, we don't have any expert evidence on that, but we have, I think, indirect evidence from Mr. Remington in relation to that at page 3416 of the bundle. But his position is that he brings all of the expertise required. And of course, he's not just a chef in this restaurant as far as we can see. He was managing the place, setting it all up, because on this account, Miss Zilla isn't even in the country yet. So he's running the restaurant, although he says he's not at this stage. And he is also the star chef. He's the person who had the 2 Michelin stars, and he's getting $39,000 a year for all of that. And according to him, he also had gifted her the Paris restaurant at the same time. So in terms of the, they agreed to do this because it was the fair thing to do, because she put some money in at the start. Actually, the solution, the outcome that they allege, essentially gives her absolutely everything, simply for being the investor, and he gets a very minimal sum for the providing all of the rest of it, all of the expertise. Now, we do have some evidence, and your lordship heard a little bit about it in relation to the receivership, and the evidence relates to loans that were taken out in the name of Five Dining. I don't know whether you recall that. They were with SocGen Cyprus. And we can see something in relation to that at page 2744 of the bundle. K, this is still. I'm sorry, I've got my reference has gone wrong. Bear with me, I do apologize. Well, let me describe what they are, and then I'll show you what he's said about them to the receiver. So you may recall there was a loan to 5 Dining, and then a corresponding deposit in Lebanon in the same sum, and the loans were for 4.6 million euros. And Mr. Manis had provided a personal guarantee in relation to those. And as I said, the collateral was cash held with a Lebanese bank. But there was also.
And where did the cash come from?
Well, we'll see. I mean, we obviously we'll see what Mr. Manis says about it. But essentially, we say that what Mr. Manis has told the receiver is that the cash came from him. But not only that, there was a surplus, because in addition to that arrangement, there was another 2.7 million euros, which was paid to a Lebanese gentleman called Mr. Elias Dumay. Now, that loan came later, but it's been described as coming from the same pot of cash. So if we look at an email from Mr. Manis to the receiver, it's at page 3280.
Yeah.
So if you look about 2/3 of the way down, this is an email from Mr. Axel Manis to Mr. Stubing, who's the receiver. And if your lordship looks down to, it's about the middle of the page, D continued. So you see there in 2019. Do you see that, my lord?
Yeah.
In 2019, SocGen Cyprus, owned by SocGen Lebanon, granted 5-year, 4 million euro facility, later amended to 4.6 million in 2020. All documents that have not been already provided can be provided. And then Elias Dumay, the 23 June 2021, a loan by FDC for 2.7 million euro, which was the excess of the funds advanced by me to FDC as cash collateral for the 4.6 million euro 5-year loan. This excess was repaid to my order as a loan to Elias Dumay, as evidenced by the bank statement already provided to you. So what he's telling the receiver is that, firstly, the money which was used as cash collateral for the 5 Dining loan, 4 million, 4.6 million, came from me, he says. So that's from him. And not only that, there was a surplus. So there was more cash than the company needed in 2019 when it was being set up. So all of that clearly contradicts the tale that we're being told by Ms. Ziller, which is that she provided the investment for the startup because he did not have the cash to do it. So that critical explanation for this arrangement is simply false, by his own words.
I'm just looking at the dates.
Yes.
2019. Yeah.
Yeah. So we don't know precisely what the loan was for, but given the dates, it seems to be the money that was used to start the company up. So the fit out and so forth. So the position appears to be that he had some cash in Lebanon, but presumably couldn't get it out of Lebanon. So he used it as collateral, gave a personal guarantee, got the loan. In other words, he had the money, it just wasn't accessible. That seems to be the inference. And then he had some more money, presumably also in Lebanon, which he used as a 2.7 million euro loan to Mr. Dumay. So had he needed more cash for the startup, no doubt he could have used that cash as cash collateral for a larger loan. But there's no room and no need for Ms. Ziller to be providing cash. And then said I was going to give you 5 points, but there's one more point, which is that when he obtained that loan in 2019 from SocGen, Mr. Manis signed a document in which he called himself the beneficial owner of 5 Dining. And he undertook that he would stay the owner of 5 Dining. That is in bundle G. And it is 2273. So you see there, beneficial ownership undertaking provided in November 2019. And he says, I, Axel Manus, hereby agree and undertake that from the date hereof, and as long as the company and after called 5 Dining Corporation Limited shall maintain an account opened in the books of your bank, I shall not sell, transfer, assign, or otherwise dispose of the shares of the company to any third party without written notice, and undertake to advise you of any change in the shareholding structure of the company. And then he signs it, signature of the beneficial owner. So at that stage, he's telling the banks he is the beneficial owner. He's telling us now, or telling Mr. Stubing now, the money came from him. And so we say that the short point is, firstly, given the way he presents his claim, he needs to establish that he was the beneficial owner before the transfer to 5 Aces. The presumption is that he is he wasn't the beneficial owner, that Miss Ziller was the beneficial owner before the transfer to 5 Aces. The presumption is that he was, because he owned them. There's then the admission that the transfer to 5 Aces was only legal, and the very slim evidence that we've been provided with is contradicted by Mr. Manus's own contemporaneous documents and subsequent admissions. So that's the sort of first part of those submissions as to the position in 2019. But there are, we say, a range of other factors which support the conclusion that Mr. Manus was always the beneficial owner. And the first point here, we say, is that one follows the money. So I'll show you this in a second, but from the receiver's report, it is clear that Mr. Manus has been drawing down on the shareholder account, and Mr. Manus has been receiving dividends throughout the period of the existence of the company. And that's both before, and that's also after title was transferred to 5 Aces. So it's not a function simply of him being the legal owner. So I'll show you this in a second, but one can see a situation where if Mr. Manus was the legal owner holding the shares beneficially for Miss Ziller, you might be able to explain Mr. Manus drawing down cash as the shareholder and then handing it to her. But in following 24th August or 17th August, depending on who you agree with, 2020, the title is transferred to 5 Aces, and on the defendant's case, as at that point, she is both the legal, well, she's the beneficial owner of the shares and in control of the legal owner of the shares. So there's no reason for him to be dealing with the shareholder account. The receiver's report is in bundle K. It starts at 2760. I think it's tab 147. And if we go down to 2775, you see this, the findings of the receiver in relation to the shareholders' equity account. I mean, firstly, we see 2774, the receiver deals with this Elias Dumais transfer and simply records the facts that we've I've been mentioning to you about the nature of that, and so in September 2020, from funds totaling 7.49 million deposited with the company, Mr. Mannis transferred 4.6 million to the fixed deposit security for the company's loan, and then purportedly received the majority of the balance of the total deposits, being 2.7 million. So that's the money that he says he loaned to Mr. Dumay. And then we go forward to the shareholders' equity account, which is on the next page. And you will see there the share capital of the company, and then the shareholders' equity account, retained earnings and losses, and then total equity left. And then you can see what's happening under the shareholders' account. It starts at a credit of 43.5 million dirham, this is. And then you see he's credited 3 million for dividends. And then there's drawdown in shareholders' account, almost 20 million. And then another one drawdown of 3.8 or so. And then what the receiver says in the notes underneath, the company's financial report and management accounts show that although the shareholders' equity account remains positive, with a balance of nearly 23 million dirhams as at 31st October 2022, Mr. Mannis has drawn down a total of 22.8 million between 31 December 2020 and 31 December 2022. I think that the sum might just be a slight error. I think it should be, he's drawn down 23,726,593 if you add up those numbers. It looks like the receiver's just adopted the amount that's left as the amount that was drawn down. They're close, but not quite exactly the same. And then it says part of this was funded from a 3 million dirham dividend paid at the end of December 2021. So it is Mr. Mannis who is cashing in on this company, who is taking out cash.
What's the total of the 19,938,640 and 3,787,953?
I make it 23,726,593.
Okay.
So that's the first point, is that he is acting like the shareholder in taking money that would be the shareholder would be entitled to.
We haven't got the actual dates of those drawdowns. Just between 31st December 2020 and 31st October 2022.
Yes, that is all we've got. I think that's all we've got. Yeah, I don't think there's a profit and loss account that we've been provided with. I don't think as the creditor we've been provided with all of the underlying documentation. The profit and loss follows, but it won't tell you the dates. It breaks them down into year periods, but I don't think that will deal with shareholder position.
But anything after the 24th of August 2020 is directly relevant.
Yes, and all of this is after that date.
Yeah.
I mean, we say it would all be relevant because he's the one taking the money, and therefore prima facie that means he's the shareholder. But as I say, if his position was that he was holding it on trust for her, then you might see that he could also be dealing with the dividends on trust for her. But after that date, he's just the one with access. I think the second point we then make is the position that was taken on the receivership application. Your Lordship will recall that amongst other things, it was said that a change of direct ownership in the company, or a change of control of the company, could lead to the company losing its license or losing its lease. You may recall there was a bit of skirmishing and the company tried to intervene in relation to that. And if we look at bundle K, page 2599,
Yeah.
And it's paragraph 5. Have I got the wrong page
It
again?
doesn't look right.
Oh, subparagraph 5. It's paragraph 16, little 5. That's why. 2599. These are the submissions that were put in subsequently by. It's a speaking note prepared by the company itself. You recall you didn't allow the company to attend, but at 2596, what they did was they produced a speaking note, and in the speaking note was inserted various bits of evidence which hadn't actually come to light yet. But you'll see that one of the things that is being said at paragraph 16.5 on page 2599, the first defendant's role is hardwired into the business, and without his involvement, the nature of the sale is directly affected. More significantly, the price is substantially affected. For example, see the license, which is a fundamental part of the letter of intent, and then they reproduced elements of the license, which required, and if you look in the middle of that, it's a substantial element of licensor's agreement hereunder that 1, Mr. Manus has a direct or indirect majority interest in the restaurant, and that 2, he is and remains at all times in charge of the operation and management of the restaurant. And in the same document, if you go down to page 2601, paragraph 8, they reproduced an extract from the Articles of Association of the company, which state that Mr. Manus's authority was actually written in to the articles of the sort of hardwired into the into the company, and so what they were saying at this point, implicitly, if not explicitly, was that if Mr. Manus was to be removed as owner of the company or as being in control of the restaurant, then that could cause the company harm. And so implicitly, they were inevitably saying that he was both the owner of the company and in control of the company. And this is in November and December 2022. The third point is that Mr. Manus was clearly in control of the company. Now, of course, control doesn't necessarily mean ownership, but it's potentially an indicator, particularly where you have a small, centrally controlled company like this. And you've seen the Articles of Association. You'll recall asking counsel about this question. You asked Mr. Taylor, is your client in control of the company? Now, the answer was less than clear, but at 2620, in the same bundle, you'll see the extract from the transcript of exactly what he said. 2620. And you asked the question directly, Mr. Taylor, is your client running the company currently? And there's quite a bit of prevarication which goes on down to 2622. And it looks like they accept that he was in control of the company. So it's not entirely clear. And then
I like the idea of Mr. Taylor working in the kitchen of a 5-star restaurant.
we've all done jobs like that. And some days they're quite appealing, I think, but it depends who you're working for, I suspect. And we know that he was in control of the money, both on the operational side and also on the shareholder side. We've seen that from the receiver's report. Now, he has previously lied about this in evidence to this court, because, sorry, in evidence actually to the English court largely. So if we go back, I'm afraid we're jumping around a little bit.
Well, we looked at that a moment ago, didn't we? Manus 6.
Yes, Manus 6. So paragraph 20, where he says that he had no control. Absolutely. But Miss Ziller has similarly also told similar lies in these proceedings in her first affidavit. out, and we looked at that as well, paragraph 12, where she said that she was, where she said it was controlled by her.
Where was that?
2545, paragraph 12 of her affidavit. So what she says is that the shares were transferred to Five Aces, which was fully owned and controlled by her. She then says that the agreement was that she would move to Dubai and take control of the restaurant and ownership of the restaurant. And then she says all of that was delayed, or at least the transfer was delayed by COVID until August 2020. The implication being that they consummated and performed their agreement at that point.
Well, I didn't think she'd ever specifically said that she actually
No.
ran the restaurant.
I think that's fair. I think it's probably an implication that we'd have to draw from the evidence that she gives, which is that everything was held up until August. The agreement was that she would own and control it. The fourth point is the nature of the agreement that they say they reached, possibly in November of last year, to agreement to sell the shares back to Mr. Manis. The original price, as I've said, was said to be $250,000 US. They then agreed to reduce it to 500,000 dirhams. And there are 2 points here. Firstly, whatever the price, it bore no relation to what they thought the value was, because at exactly the same time, Mr. Manis is trying to release 6.5 million euros by selling the business.
Yeah.
And then the second point is the adjustment of the price itself makes the whole thing, just demonstrates that it's completely artificial. It's a tactical arrangement that it doesn't reflect the value that they held. The fifth point is, some of these points overlap because my first set of submissions was really discreetly about the position pre-August 2020. But so I'll run through these very quickly. The fifth point is about the ultimate beneficial owner register, and you've ordered both defendants to produce it. I can give you the chapter and verse on that if you like. It's in the note, but I can take you to the order if it's helpful, but it should be in my skeleton. And then the sixth point is that they have shown form for this sort of thing. And there are 2 examples of this. The first example is a company called Ragnar. Ragnar was referred to in the English judgment. It was transferred to a Mr. Alkan on the 4th of July 2015. Sir Michael Burton found that Mr. Manis had falsely claimed to have no interest in Ragnar. The reference in the bundle is page C133, paragraph 27. The second example is the Paris restaurant itself, which, as I've said, is owned by what is now a Belgian company, MA Development. This is worth just looking at briefly because it shows that Miss Ziller is prepared to say things that are not true to assist these schemes. Just to get the facts out, the company was transferred to Miss Ziller in May 2020, and then in the English proceedings, Mr. Manis admitted that that was not a true transfer of beneficial interest. So I'll show you that. That's at bundle K, page 2846.
Yeah.
And paragraph 19. Sorry, my computer is being slower than everyone else's. Yeah, so we've seen this. So he says, in relation to the Paris restaurant, second line, I confirm that I do not dispute that I have full beneficial ownership interest in MA Development, which in turn holds MA Mad Atelier, the owner of the Paris restaurant. It's correct that I transferred the legal ownership to my wife in 2020 for estate planning reasons. However, in order to avoid any issues with that since the judgment, I've arranged for the legal ownership to be transferred back to me by an act dated 3 January 2022. So he gets them back on the 3rd of January 2022, and then on the 18th of January 2022 he changes his mind. So this is about 3 days after he gives an undertaking not to deal with his interest in his assets, and he transfers those shares back again to Miss Ziller. So that's about the same time as the 5 dining shares are transferred to her. And so what, as I mentioned this at the outset, Mrs. Ziller said that the transfer back from her to him on the 3rd of January was done, she says, without her knowledge. That's her evidence in these proceedings, in her affidavit. And the reference to that is page 2545, paragraph 10. It's just 2 paragraphs before the one we looked at a moment ago. And she says, I'll just read it to you so you've got the reference. As our relationship deteriorated further during the divorce proceedings, on 3 January 2022, Mr. Axel Manus attempted to unilaterally, without my knowledge, revoke the donation. And so Mr. Manus's evidence in England was, I transferred the shares to Miss Ziller for, quotes, estate planning purposes, but I accept that it didn't transfer the beneficial interest. So to simplify things, I transferred them back to me again on the 3rd of January. And they then go back on the 18th of January to Miss Ziller. And Miss Ziller says, well, when they went back to her, she didn't know about it, and it wasn't with her permission. But we have the share register from Belgium, which shows something different, we say, because if you go to page 3552, it's going to be sideways probably on your page if it's like mine. 3552, this is the registration document. The first one is for Mr. Manus Axel, you'll see, and the second one is for Miss Ziller Catherine. And each of them show the shares going backwards and forwards. So 26th of March 2019, he subscribes to the shares. And then donation on the 20th of May 2020 to Ms. or Madame Catherine Ziller. You'll see 2 signatures against that. And then 3rd of January 2022, you'll see the quotes, donation comes back to her again. His shares go down. And you'll see that that is signed against each by 2 signatures, which match the ones for the other quotes donation. And you'll see the same entry on the next page in Ms. Ziller's register. And so the short point is that both Mr. Manus and Ms. Ziller have signed the share register at each stage. And so the ledger appears to show her signing against the revocation of donation on the 3rd of January 2020.
Just bear with me a moment.
Yeah.
Right, I'm printing it off. I have trouble reading it sideways.
Of course.
Right.
So you'll see there's 4 entries for Mr. Manus because he's got the incorporation and then the subsequent transfers. one out, one in, one out. And there's 3 for her because she gets 1 in, 1 out, 1 in. And the point is that there are 2 signatures next to each of these entries.
It's a revocation on the 3rd.
Yes. Revocation de donation.
Bizarre, isn't it?
Well, yeah, I mean, so this is a January 2022 is when the ducks are coming home to roost, because they by this point they know the outcome in the English proceedings, and they know that there's a freezing order application. There's then he disinstructs his lawyers, attends the hearing on the 15th of January, and says, "I give you an undertaking not to deal with my assets." And then 3 days later, you get all of this activity. You get the transfer out of the MA development shares go back, and you get the 5 dining shares going from 5 aces.
Yeah,
So
I was just checking the dates against your.
yes.
I see. Yeah.
So I think there's a day difference, isn't there? The 17th of January and 18th of January.
Yeah, I've got you. All right. Thank you.
And thank you. And then the next page after this, there's a series of translations of the documents we've just looked at. But then the final page, 3558, is the banking ledger for MA Development. And you will see that it is the current account of Axel Manes. That's in the grey box towards the top of the page. And so what this appears to do is show Mr. Manes using the MA Development money effectively as his own. So he's mixing his finances up with the, well, he's certainly in control of the finances there. And so we say this looks rather like what's been going on in the DIFC. That there appears to be something of a playbook, and this is, we say, evidence of similar facts.
Where do we see his name?
It is towards the top. There is then a grey column. Sorry, a grey word.
Yeah. Compte courant Axel Manes. Yes, I got it. Yeah. Yeah.
That was the 6th point that I had. The 7th point is the timing point, that the timing of these transfers demonstrates motivation. So just to remind you, we've got a summary judgment application in London on the basis that there were prior French proceedings, and so there was a res judicata point, it was said. That failed in April 2020. And then in July, the end of July 2020, 29th of July, the English claim is amended to plead a fraud case. And then on the 17th of August, you then get the transfer to 5 aces. So what we're saying is that there are significant events in England which appear to trigger transfers of assets. As I've mentioned previously, when you get to the end of the story on the 7th of January 2022, the claimant applies for a freezing order in England. And on the 13th of January, the application is adjourned, and Mr. Manes is giving undertakings not to deal with any interest in the company. And then you get 17th of January, the 5 aces transfer to Zilla and the children. and then 18th of January, the MA Development transfer to Mozilla at the same, effectively the same time. And then the 21st of January, he steps down as director and says he's got no further role in the company after that. So we say the timing of the movements of the shares is indicative of him trying to put distance between himself and the assets as he increasingly anticipates the prospect of enforcement. The eighth point is that there have been inconsistencies in the way in which he's explained the 5 aces transfers to Mozilla and the children, and in particular in the way that he put it in the Dubai court proceedings. So I'll just show you this very briefly. In the Dubai court proceedings, he presented the transfer from 5 aces to the children and to Mozilla was presented almost as if it was an obligation on him to make the transfer. But if we go to how he explained it explained that case. If we go to the bundle D, page 209, see one of the witness statements in this case. And it's paragraph 13. This is his first witness statement in these proceedings. Paragraph 13, he says, if the Part 7 claim is successful and the Dubai execution order is set aside, I will be liable to pay the second defendant damages of 5 million euros. Accordingly, on the 20th of April, I issued a counterclaim in the Dubai court supporting the second defendant's contention that the Dubai courts are the competent court to deal with this matter and seeking damages from the claimant in the event that the Part 7 claim is successful. So, and I need to show you the underlying documents just to explain what he's saying here, but basically he's saying the Dubai execution order implemented the agreement between the parties. If we make the declaration that we're seeking and therefore find that he is still the owner, he will not have complied with his obligations under that agreement, and therefore he will be liable. And that's how it comes across if you go to bundle E, page 460. We see that. This is an extract from his counterclaim. It's paragraph 2. Whereas the plaintiff failed to pay these claims, a consensual judgment, so the plaintiff being him, was issued to dissolve the marriage contract, which included the following, third bullet, to obligate the plaintiff to intervene the children under custody in the company into the DIFC. So he's saying the obligation was on him to introduce the children as shareholders of the company. And then 2 bullet points below that, in the event that the plaintiff fails to fulfill his obligations included in this convention, that's the agreement, or if it becomes clear after divorce that the information provided by him is false or incorrect, he's obligated to pay an amount of 5 million euros as temporary compensation. So the point is that in the Dubai proceedings, and as explained to this court in his first witness statement, he's presenting the obligation to make the transfer from 5 aces as being an obligation on him. And that's how we had understood what they were saying in the first place. He had the asset, he got divorced. In the divorce, the asset was transferred to the wife and the children. But actually, as we now know, the case is different. The case is, in fact, that she always owned the asset and that it was an obligation on her to make a transfer of part of her ownership interest in that asset to the children in 33% shares. And that emphasizes the next point, which is the fact of the DIFC enforcement proceedings in respect of the divorce. If you recall, what happened next was that Miss Ziller took the Dubai divorce decree to the Dubai execution judge, got an order for its execution in the DIFC, and then effected the change of ownership of the company on the register by enforcing through the DIFC courts. So that's completely inconsistent with their own case in a way, because on their case, Mrs. Ziller is the one who was obliged to transfer the shares to herself and to her children. But, and I can show you the bits here if it's helpful. We're in bundle E. If we go down to page 1278, we see the agreement itself.
Yes.
So we have the divorce decree, which declares, and then we go down to 1280, which is the agreement. And you'll see the agreement identifies as first party, Ms. Ziller, and the second party, Mr. Manis. And then paragraph 3 is the relevant part of it. The first party, that's Ms. Ziller, must associate as partners, as shareholders, the children, Enzo Manis and Santino Manis, as 33% in the company called Five Dining Corporation Limited. So the obligation is on her to do that. And then at 1284, we see what she does next. You'll see that is an application to the Dubai Court's Personal Status Court for execution, subject execution.
Sorry, bear with me a moment.
Sure.
1284, did you say?
1284, correct, yes. So you see the date is the 10th of February 2022. It's the top left.
Yeah.
And then you'll see that it is a letter to the Dubai financial market. So it's been produced by an execution process in the Dubai courts. You see that subject execution number, and then identifies the court, which is the marital Sharia execution circuit. And then the applicant is Miss Catherine Ziller. And so she is actually applying to enforce the order effectively against herself. And then 1289 is the corresponding process in the DIFC court. And the sort of oddness of all of this is demonstrated by the fact that she can't identify a judgment debtor. She's the applicant, but also the obligor. So the point here is that if Miss Ziller was genuinely the owner of Five Aces, and she was genuinely obliged to make those transfers, she wouldn't need an enforcement process to do it. People don't generally enforce orders against themselves. I say that's rather understatement. People never enforce judgments against themselves. And so the only possible reason to go through that process was to create a paper trail and to set up the argument that somehow this was beyond the jurisdiction of the DIFC court, beyond the competence of the DIFC court's powers. So that in itself, we say, indicates that this is all window dressing. And then the final point, which I've already made in relation to the first aspect, and I won't repeat, is the wide disclosure order. Nothing's been produced. The order is at page B 105, your lordship ordered pretty much all of the requests be answered, save limiting some of them in relation to financial documents showing the payments alleged to have been made by Ms. Ziller for the purchase. The schedules themselves are at F2041, but I've highlighted I've summarised the most important paragraph 37 of my skeleton, which sets out the sorts of things. And again, we say that you can produce, you can make adverse inferences, draw adverse inferences as a result of that. Those are all the points that I was going to make. The only other thing that arises is that the effect of the divorce decree is still pleaded at paragraph 6 of the first defendant's defence as being somehow preclusive, somehow taking it out of your hands. That's on page A9.
Yeah.
But you have already dispensed with this argument, and to remind you what you said, it's at page B88, paragraphs 21 to 22. And the short point is that even if the divorce decree is binding, it could only bind my clients as to the status of the divorce.
This is part of my judgment, summary judgment, is it?
This is part of the summary judgment, yes. It came up in a slightly different context because I think it came up in the context of the jurisdiction sort of complaints on the basis that it was an abusive process because we were trying to go around the onshore proceedings, that in order to exercise jurisdiction, that there was still some requirement to demonstrate that there was a legitimate purpose to the enforcement, and there wasn't because we're bound by the Dubai court proceedings and so on. What I haven't done is reproduce my submissions to you in that, but you found it sufficient just to rely on that particular passage of Dicey recorded at paragraph 21.
Yeah, and this was in the context of the onshore Dubai court already saying that this was really a matter for the DIFC court.
Right.
Yeah.
So that is all I was going to say to you on the merits. I've set out the declaration that we seek. It's at the final paragraph of my skeleton argument. And unless there are any other questions on that, that's all I was going to say. Sorry, the other one final thing. This skeleton argument has been out there for 2 weeks now, so we produced it very early, and there's been plenty of time for comment.
Yeah. Yes, all right.
No, the one other thing that arises, my lord. Sorry, I'm cut across you.
No, carry on.
I was just going to say, I mean, I don't know how you wish to deal with the judgment itself and the decision, but the question of costs will arise, and we're obviously keen not to come back and do that all again. So we have the long cost schedules, and Mr. Stossard has given his confirmation in relation to them. There are issues of principle, 2 issues of principle, and then there's an issue of interim payments on account. The 2 issues of principle. Yeah, go on.
What I was proposing to do, Mr. Montague-Smith, was to make the declaration here and now, but to put my reasons in writing, which I'll do during the course of the rest of the day.
Very good. Thank you.
So,
Yes.
So costs we can deal with, yeah.
Thank you. All right. Now it's a little bit complicated because there's lots of schedules and it's been a long ride. But
Do we need
there
Mr. Stiles?
I hope we don't. I don't think we do need him, but I'm sure we'd love to have him if he's available.
Is he in a
I am
position?
available if you need me.
You're looking more respectable than when we last saw you.
Yes, my lord.
The implication being that he looked less than respectable previously, but
No,
I'm sure we'll
there's-
smooth over that.
Don't take that as a criticism, Mr. Stiles.
Not at all.
I think
Mr.
we
Starr.
simply would like you to affirm something in relation to the costs, that's all. So are you happy to use the words the affirmation or an oath, or what would you like to do?
I'm happy to affirm.
Right, well, if the associate could administer the affirmation, that would be helpful, please.
Yes, Judge Cooke. Mr. Style, can you please state your name and occupation for the record?
My name is Simon Guy Christopher Style, and I'm a solicitor at Mishkondareya Solicitors.
Thank you. Please repeat after me. I solemnly declare and affirm
I solemnly declare and affirm
that the evidence I shall give
that the evidence I shall give
will be the truth, the whole truth, and nothing but the truth.
will be the truth, the whole truth, and nothing but the truth.
Thank you.
Thank you. Mr. Starr, do you have a copy of the bundle?
I have a copy of the schedule that I
Oh, you have a
signed.
copy of the schedule. Excellent.
Yes.
And could you just show us? I think it's the same as the schedule that is page 3592. my lord.
Yes, it's the one bearing my signature.
Excellent. And can you confirm that insofar as that schedule reproduces costs identified as being incurred in relation to Mishkondareya, that those costs do not exceed the costs which the claimant is liable to pay in respect of the work that the statement covers?
I can confirm that.
Thank you very much.
And all of that specifically relates to the DIFC costs,
Yes, it does.
and not to other work that you've done in other contexts.
Not to other work.
Very good. Thank you very much. I'm sorry to put you to any trouble, Mr. Starr. It was
No-
simply
no
that
problem at all.
I thought you were there immediately because we saw your little circle in the corner, but there we are. Thank you very much.
Thank you.
Thank you, Mr. Starr. Thank you. All right, my lord.
You're free to sign out and do whatever you want.
So what you will have in your bundle is firstly at page 3590, a schedule of costs orders which have already been made. And then following that is the schedule that's just been affirmed. And that is supported by a series of schedules which give further granular detail to the numbers that appear. But just dealing with the costs orders that have already been made.
Yeah.
And I'll try and explain how we want to deal with this. Firstly, there are two issues of principle. You will see on the schedule of costs orders, costs of the freezing order were reserved.
Yeah.
And so we need to deal with those. And then the second point is the costs of the claim as a whole. Those are the points of principle. And then there's an application for interim payments on account. And that gets a little complicated because your lordship made one order for an interim payment on account in relation to the receivership order, so we need to strip that out. Some orders have been made without any, and I'm going to ask you to make an order on the indemnity basis. Some have been made without any suggestion of a basis, and therefore we assume those are on the standard basis, and that may affect the interim payment. So in relation to the freezing order, we applied for it. It was plainly, we say, justified. There have been lots of movements on the account. The order was made by Mr. Justice French in the first instance and continued, and no serious challenge was ever made to it. So in the ordinary order in those sorts of cases would be claimant's costs in the case.
Yeah.
And then the case having succeeded, you'd get the costs. In relation to the claim, as a whole, we seek those costs on an indemnity basis. I think my submissions on this are probably fairly obvious, but I put them in make three short points. Firstly, is the nature of the claim itself. When it comes to enforcing a judgment, you've already fought the claim at length for years. And so anything you don't recover on enforcement simply eats away from what you've already been established to be entitled to. And ultimately, once you've lost once, you ought to probably pay. The second is the dishonest nature of the defence. Lies have been told, and I've been through that in some detail already. And then the third is really the approach to this litigation. And you can tell from the number of costs orders that the sheer number of applications that we have had to absorb and deal with some success originally for the defendants. When they applied for a JJC stay, they got it on paper, and we had to go through a whole process of trying to set it aside again. And there have been lots and lots and lots of that sort of thing. Lots and lots of submissions fired off last notice, and the receivership application was a taste of that. We even had the company trying to intervene at the last minute, running points which were inconsistent with the case. So there's been a huge amount of manoeuvring. All of that, and I'm not going to labour the points, but all of that, we say, takes this case out of the normal run of cases and justifies an order on the indemnity basis. That's all I was going to say in relation to that, unless you've got any questions.
No, insofar as orders have not already been made in relation to costs on the standard basis, I'm entirely satisfied, one, that you should have your costs, and two, they should be on the indemnity basis, because essentially what has been put forward is a series of lies and dishonest accounts and efforts to prevaricate and delay the process of the court in one way or another, which takes us way beyond the norm, and indemnity costs are therefore appropriate.
Thank you, my lord. All right, and then there's an application for an interim payment on account of these costs, and that
Yes.
there's a degree of complexity here because of the way that the different orders interact. But just I start by saying it's quite important to get money ordered on account in this case. The reason being is that if money can be recovered through the receivership, it ought to be applied to set off the costs first. Otherwise, we've just got a costs order from the DIFC courts, which we then have to take somewhere else, rather than going around the world trying to enforce the English order, as we are already doing.
Yes.
If that makes sense. So
I can't make any order as to priority of payment of debts, can I? I mean, it's just a question of me making an order.
No, I think that we can deal with that with the receiver.
Yeah.
As to, and it may be that you can
when
money comes to be released.
It's self-evident that if there's a receivership in the DIFC, DIFC debts ought to be settled.
Right, thank you. That's very helpful. All right, then the next bit is I've shown you briefly the schedule of costs orders. You've then seen briefly the summary of all costs, and then over the page on 3593, you've got the breakdown of the various different tasks, some of which orders have been made. Some of them have been made against the first defendant only. Others have been made against the second defendant only. Those which have been made have largely been made on the basis on the standard basis. And so you will see at the bottom the total sum spent on all of this. At the bottom right-hand corner is just over 1.3 million US. And the way it works is that when you put those all together, very nearly half the money is referable to an order that has already been made. And where it works out, and I think the best thing for me to do is just tell you what I say the figures are. There's no one here to say otherwise, but again, there should be. The existing orders made against the first defendant, in respect of which there is no interim payment order made, is in total, we say we've spent a total of $360,335.72. So that's in relation to setting aside your interim payment order in relation to the receivership and all other costs for that. Just orders against the first defendant, Mr. Mannis, by himself, 360,335.72. I think what we're asking for in relation to that is about 65% of it. You've got the breakdown and the detail of it, but we'd ask for 235,000 in relation to that. The starting point is 50,000. Sorry, 50%. Apologise.
Yeah.
But there is Court of Appeal authority in, for example, the Al Rehab case, that where in realistically there is unlikely to be benefit in pursuing an assessment, you can push it up a little bit. We would say that in relation to the existing orders, they're on the standard basis. 65% would be about right. So that's 335,000 US for that. As against the second defendant, existing orders that have been made in relation to which there is no interim payment order, the sum is 42,648.83.
These are against the second defendant on her own.
On her own, correct.
Yeah.
I'm sorry. Bear with me, I do apologize. I think we would be asking for about 28,000 US dollars. Again, it's rough, it's a little bit more, but it's roughly 65% of that. And then there are orders made against both, again, without definition, and that is 89,175.81. So we ask for, again, about 2/3 of that, so 58,000 US in relation to that. And that then, combined with the receivership, which has already got cost orders in relation to it, that leaves in the bucket of general costs of the claim 657,684.30. Those are sums that those include the freezing order costs, and they are sums in respect of which there is currently no order has been made, or they go into the costs of the claim. So in relation to that, given the indemnity basis for it, we would be seeking around 75% of that, which comes out at, I make it 495,000 US dollars. So the orders, I mean, they'd need to break them up a little bit, but the orders that I would seek would be interim payment against the first defendant in relation to cost orders already made, 235,000. Interim payment against the second defendant in relation to cost orders already made, 28,000. Interim payment against both in relation to costs already made, 58,000. Interim payment on account of the rest of the cost of the claim, 495,000. It comes out at about 70% of all of our costs, which reflects the balance between the 75 starting point for the indemnity and the 65 starting point for the standard basis.
Yes. If you were appearing for the defendants, what would you be saying?
I'd be horse trading, I suspect. I'd be saying, well, you start at 50 and you need a reason to go higher.
Well, I don't have a problem with that. I've never seen the 50% rule as being anything other than a starting point. The basic question is always, what are you confident is going to be recovered? It's as simple as that.
Yes,
and in the ordinary way, as you were saying, 2/3 is certainly what one expects to be recovered. But what I was really asking about was, you know, when one's looking for the sort of arguments that may be made about either rates or extent of work done or churning or, you know, whatever fat in the bill.
I mean, I think that so you'll see the rates. The rates are at 3594 for the Norton Rose team, and you've got the rates at 3614 for the English team and various other places. In fact, actually 3614. I suppose what they might say is, well, there's two law firms, so there might be some overlap, but I think that that's just a feature of needing to come to the DIFC. I think it was hoped that when there was litigation in England, it would only be necessary to use a single law firm, and Mishcon Rare does not have an outpost in the DIFC, so it needed assistance.
Yeah.
I think the one thing that has been said along the way by Mr. Taylor is that this is a campaign of destruction being brought by the claimant against the defendant. I mean, there's no evidence to support that, and actually, by far and away, all of the activity on this claim has been directed either at shortening the process, trying to get through to the trial, or on the other hand, resisting the flurry of endless applications that we've received from the defendants. So we have made applications, but we made applications to try to shorten it with the immediate judgment successfully. We made applications to set aside the orders that were made on the JJC applications, because if we hadn't done that, the claim would have been stayed indefinitely. It would still be stayed. It would be stuck in JJC. So we haven't taken any steps, I would suggest, which would be could be criticised for being overbearing. Amongst other things, for example, we've not made an application for committal in circumstances where, in our view, it's pretty clear that Mr. Manus is in contempt. But, you know, we've taken what I hope is a reasonable proportionate approach to all of this. It is cost us a fair bit of money, but all of that, obviously our interests are aligned in trying to get through this as cheaply and efficiently as possible. That's just what it costs when a party takes such a determined, entrenched approach. I mean, in terms of the rates, you know, they likely will exceed the guideline rates, but the attempt has been made to distribute the work proportionately and effectively between at the different levels. But there we are.
Where was the Mishcon Rare bill again?
So it's
rates. I'm looking wanted to see.
Yes. So the rates are, you can find them in various places, but for example, 3610.
Okay. Yeah.
Seeing if there are different personnel identified. There's one other, the Sean Hard. Sorry.
It's basically Mr. Style, is it?
Largely Mr. Style.
Yeah.
They're not exorbitant London rates.
No. All right. I don't have any problems with any of those figures. So it's 235,000, 28,000, 58,000, and what was it? 493,000, was it?
495 I had.
495. Well, that's, yes, close enough. All right. Payment on account.
Thank you very much. Did you want me to record those in an order? Is that the best way?
Yes, I'm just trying to work out what the form of order is going to be on costs.
It may be a question of me going through the schedule of cost orders and referring to those cost orders.
I'm afraid I think it is. I think it's will be a need to go through them in order to take account of what has already been ordered. And including where there are interim payments and so on, and then totting up the total of interim payments that I've made and attributing. They don't need to be allocated to each of the individual orders. You can do it in a total, but they just need to be referred to, so we know exactly what is being done.
So you'd like a recital that identifies each of the cost orders that have been made?
I think what it needs is probably the schedule of orders attached to this order. If you put the schedule, and then in the body of the order that I'm going to make, you make it plain where there is a fresh order being made today.
Yes.
And what is essentially wrapped up in it. In
Yes.
terms of new order for costs, and where an interim order is covering, which particular previous orders, and interim payment covers numbers 1, 2, 3, 4, and 7, or whatever it may be.
Very good.
I'm try and make it simple, but
I should do my best.
I'm afraid it won't necessarily be simple. All right. Is there anything else at this stage? Hopefully, I'll get something done during the course of the day, and once it's been through the usual channels, the order can be drawn up.
Thank you, my lord. I will do the same and try to ensure you have a draft order with the registry today.
Brilliant.
Nothing
All right,
further. Thank you.
Thank you very much.